So it's my very great pleasure to welcome everyone to this afternoon's sort of mini symposium in honor of one of the great triumphs, really, of constitutional interpretation, a book written just over 40 years ago that we're still talking about and that still in some ways dominates. It started a field and in some ways still dominates the field. This is the 40th anniversary, except that for those of you who are better at arithmetic, you may have noticed that it's not really the 40th anniversary because it hit right in the middle of the pandemic, and we wanted to hold this event in person. And so here we are celebrating the 40th anniversary of John Hart Ely's great book on its 42nd anniversary. But who cares? We're all law students or law professors, and we don't do arithmetic anyway, so I guess it doesn't much matter. But I'm very happy to welcome our speakers for today, and then I'm going to sit down. Let me tell you what the program kind of looks like. So first we're going to be hearing from Dean Martinez and former Dean Kathleen Sullivan about John Hart Ely's book, the substance of it, the context, the importance. And then we're going to the second group, which is former Dean. By the way, how great it is, Dean John Hart Ely's book, and we have three of our former and present deans speaking with us today. And so former Dean Larry Kramer and Jane Schachter, a great constitutional law professor here at Stanford, will be talking about 40 years later, how is the book still affecting us today? And then we're going to hear from three, dare I call them younger scholars. Everybody's beginning to look younger to me these days. But Jamal Green from Columbia, Nathan Chapman from University of Georgia, Zach Price from Hastings are all going to be talking about some of their thinking about constitutional interpretation. And what makes their theories, the thing their theories have in common, and that they have in common with John Hart Ely, is that they are all cross-cutting theories about interpretation, the interpretation project. So they're not about privacy, they're not about free speech, they're not about executive power, they are about how to interpret a constitution. And so each of them has their own take. I can kind of think of them as, modern generation, Generation X, or whatever generation we're in, John Hart Ely. So that gives us something to look forward for the end. So first, I'd like to ask Dean Martinez and former Dean Sullivan to come up and take it away.
Thank you, Michael, and thank you everyone for coming on a Friday afternoon. It's wonderful to be able to gather in person again. As Michael said, this is delayed because of our inability to hold things in person, and so it's really nice to see everyone here, and especially to see so many former deans of the law school. I think it's a really special occasion to talk about this book by one of our former deans and continue the great tradition of discussing and arguing about constitutional law here at Stanford. And it's especially nice for me to have former Dean Sullivan here. She was the dean who hired me, and then Dean Larry Kramer was the dean who was dean while most of the time I was an assistant and associate professor. But I always feel, Dean Sullivan, that I owe you for bringing me here to Stanford. So thank you.
Well, Madam Dean, you couldn't make a former dean any prouder than by all you've done. So thank you so much to Michael and for all the organizers of the conference, and thank you, Jenny, for doing this dialogue with me. We're going to do it as a dialogue. I'm going to start by talking a little bit about John Ely, the man. He was a dear friend, and I wanted to just enlighten some of you who didn't get to know him since we lost him so young at the age of 64, just a little bit about him. Of course, he hit the law professor's trifecta. He taught at Harvard, Yale, and Stanford, and he was Jenny's and my predecessor as dean here. And in the great tradition of constitutional law professor deans of Stanford, which of course is not just Jenny and me and John Ely, but our dear friends and colleagues Larry Kramer and Paul Brest. So, but you know, John also was, not your ordinary law professor. He was, as you can see from this gorgeous archival photograph, rakishly handsome. Not that that isn't true of all law professors. You can see this even more in the cover photo from the book. This is my original 1980 copy of the hardcover, $15 for the hardcover. It came out in my third year of law school. And he was rather swashbuckling. He dated actresses before his life with his loves, Nancy, Carolyn, and Gisela. He was also he loved the water. He was born and raised on the east end of Long Island on the water. He loved to sail, he loved to scuba dive, and we lost him at the end, perched in a house in his adopted home of Miami, overlooking the bay and looking out at his sailboat. He was, you know, irreverent, as you can tell from the prose in the book. He was dryly witty. He was immensely generous to colleagues. When he did an academic takedown, he did it in a genteel way. And for all of his swashbuckling, bold characteristics, he had a few foibles. I'll just mention one. He had a terrible fear of flying. We ran into each other by chance on a transcontinental flight from San Francisco to New York, and he moved over to sit next to me, and he held my hand so tightly for the entire flight that I still am recovering. So, you know, he was a wonderful friend, and above all, he loved his work. And I just want to share with you a story from my partner, Helen, and I had the privilege of visiting him toward the end in his home in Miami, and we visited with him for a few days, and I spent one afternoon as he puffed on his pipe looking out over the water, and he turned to me and he said, "I wrote the book I wanted to write." And I've never forgotten that moment. It was elegiac. But I also will never forget reading the book. Michael and I were students in law school at the time it came out. I was a 3L, which is why I have this well-thumbed copy still, and it was stunning. Why was it stunning? First of all, because of its comprehensive theory of interpretation, which we'll hear about from all the panelists today, but also because of its energy, the energy and wit of its prose. I mean, how do you forget a prose stylist who writes lines like, substantive due process is a contradiction in terms, sort of like green pastel redness. That voice, inimitably John's, was later a kind of inspiration to me in my own work. I felt he gave all of us license to write with a kind of energy and passion and wit that we might not otherwise have been bold enough to adopt. So Jenny, that's a little bit about the man. I think you're going to tell us a little bit about the book.
Well, thanks for that, Kathleen, because I think the idea of his personality very much animates the words on the page as you read it. As you say, one of the reasons I think it lives on is it's such a lively read. I mean, it sort of sweeps you through in a way that a lot of academic writing doesn't. The other reason I think the book continues to get attention 40 years later is that it addresses this really basic problem that all constitutional theorists are grappling with, which is you have this tension in a democracy when you have a court that's engaged in judicial review. On the one hand, democracy is all about people elect their representatives, they make the law, that's how democracy works. But the basic premise of judicial review is you have these judges who aren't popularly elected, who can strike down things that the legislature does. And that tension leads to a lot of the debates that people resolve in different ways. So originalism is one answer that is quite common in American constitutional debate to that question. Well, how do we deal with that problem? Originalism tells us, well, we go back and we try to look at the original public meaning of this text, and that constrains, in the views of those who argue for that theory, the judges from just doing what they want and relies on some higher legitimacy. That theory is unsatisfactory to a lot of people who say, well, actually it's not so clear, and also why should we be bound by the views of people who lived hundreds of years ago? So, that, sort of flaws in that argument in the popular view. Well, so I think the thing that Ely does that is so attractive and that made the book such a popular work in constitutional law is that he tries to give another answer, that something other than judges should enforce some set of values that are derived from either their own views or some other kind of source about the values of society. And the way he does that is by proposing his theory of representation reinforcement. And he does it both in a descriptive sense, like he tries to say this is what the US Constitution does if you read all the pieces of it together, and this is what the court ought to be doing. So it has both a descriptive kind of part of his argument and a normative part of his argument. And here's the argument in a nutshell, which in large part derives from famous footnote 4 in the Caroline Products case, which is a case from the 1930s about filled milk. And in Caroline Products, the Supreme Court talked about when judicial review would be justified. And in the footnote 4, the Supreme Court says, the court should be especially concerned with legislation which restricts those political processes which can ordinarily be expected to bring about the repeal of undesirable legislation. That should be subjected to more exacting judicial scrutiny. And then also talks about where prejudice against discrete and insular minorities may be a special condition which tends to seriously curtail the operation of those political processes ordinarily to be relied upon to protect minorities and which call for correspondingly more searching judicial inquiry. So Ely's theory comes out of that kind of concept, which is that what the court ought to be doing is first, on the one hand, protecting the channels of political change so that if bad law is made, the political democratic process can correct it. And secondly, should be concerned with legislation or judicial or government action that discriminates against discrete and insular minorities, because the nature of discrete and insular minorities and the nature of action against them is such that the political process alone can't check or constrain that kind of abuse, because the majority is by its nature in a democracy empowered to do what it wants, and it might use that majoritarian power to go after small groups and discriminate against them. So those are the two pieces, and he goes through the Constitution and the Supreme Court's case law and tries to describe how this is in fact a good description of what the Supreme Court is doing and should be doing. So protecting the political process, looking at things like freedom of speech or the right to vote, those types of aspects of the political process and the structures of the Constitution, and sort of goes through the Constitution and describes all the ways in which its provisions try to create this architecture of representative democracy. And then the court polices that architecture to make sure that the different components of it are working well. And then second, talking about the protection of discrete and insular minorities, where there's reason to think that there would be prejudice or discrimination that would filter into the law that couldn't just be corrected through ordinary majoritarian voting processes, and that the court has to weigh in. And so that's the sort of theory, and I think what it was so attractive to a lot of people because it addressed this very fundamental question in a kind of grand unified theory way that tried to stitch everything together. Now, it doesn't agree with all the Supreme Court's decisions. There are cases like Roe, for example, that Ely has trouble with because he doesn't think that it fits into this model. But it has the sort of appeal of trying to stitch everything together into one theory. And so that's why the book made such a splash when it appeared, as well as its lively writing style, and why people continue to grapple with those ideas from it today as they consider other alternative theories of constitutional interpretation, like originalism, that also purport to give a comprehensive view of what the Supreme Court should be doing. So that's sort of an overview for those in the audience, and I know we've got some of our 1Ls here, some of our first year students, as well as 2Ls and 3Ls, who may or may not have read the book. Kathleen, my question for you is, what would John say today about current issues involving majority rule, policing the processes of political representation, clearing the channels of political change? How would he talk about that today?
Well, Jenny, I think he'd give it a mixed scorecard. And I thought I'd talk about two concrete issues that are very debatable and controversial today, in which he might have a view: campaign finance and political gerrymandering. So let's start with campaign finance. didn't get to see a lot of the court's decisions as it moved toward a more free speech libertarian approach to campaign finance. Buckley, of course, he knew, but he didn't talk about it much. You'll find Buckley versus Vallejo referred to exactly once in footnote 27 of Democracy and Distrust, and he otherwise didn't talk about campaign finance. In the later big cases, FEC versus McConnell, and of course Citizens United in 2010, would have been news to him. So what would he have thought about that? Well, I think in part, John, you remember as Jenny described so beautifully a minute ago, John believed that courts should act to clear the channels of political change, to be representation reinforcing, make sure that political majoritarianism works as a practical matter. So in some ways, campaign finance restrictions like the Bipartisan Campaign Finance Act or the application of old campaign finance laws that began after Watergate in 1976, their adaptation to try to shut down loopholes like soft money and issue advocacy and expenditures on independent expenditures for political candidates from corporate treasuries. John would have looked at that, and I think he would have said, that's Exhibit A of choking off the channels of political change, because that is incumbent politicians who enjoy all the inherent and intangible electoral advantages of sitting in office, trying to stop challengers from spending the money it takes to unseat them and throw the bums out. So he would have said, that's Exhibit A of, to quote his line, the ins, trying to make sure the ins stay in and the outs will stay out. That's page 103. And he probably would have added a line, because he always had a line. You know, John couldn't just talk about why you might want to embrace natural law. He had to say, you don't mess with Mother Nature, right? So he would have said, the reason that campaign finance laws should be struck down is you should not put foxes in charge of guarding hen houses. And in fact, the core section of one of the central chapters of the book, the section that's called Democracy and Distrust, has the line that elected officials are the last people you should trust. Our elected representatives are the last people on earth we should trust in identifying the two pathologies that Jenny just described, the pathology of preventing political change or entrenchment of incumbents on the one hand, or the problem of prejudice impairing discrete or insular minorities on the other. So I think he would have said 3 cheers for Citizens United, for the majority opinion, Justice Kennedy's opinion, which said that, yes, corporate treasuries had a First Amendment, corporations had a First Amendment right to expend freely from their treasuries on independent expenditures in support of the defeat or election of political candidates. But then you have to say, or would he? Because after all, his theory was, as he described it himself, his hyphenated expression with a comma was, it's a participation-oriented, representation-reinforcing approach. And of course, Citizens United illustrates a tension between representation-reinforcing and participation-oriented, because of course the proponents of the legislation thought that they were enhancing democracy by preventing the disproportionate influence on electoral outcomes of large corporations, large unions, or well-financed and highly motivated special interest groups. So the dissenters in Citizens United might have said, well, actually, Ely should be on our side, because we're the people who think democracy will be enhanced and the process of representation will be protected and reinforced if you force the support of political candidates by a larger number of people who contribute in smaller amounts, and so prevent us from being on a fast track to plutocracy. So I could see somebody trying to convince John Ely that the majority was right, and others trying to convince him that the dissenters in Citizens United were right. I think in the end he would have sided with the majority. I think he, in the end, would have thought that Citizens United express an anti-incumbency, anti-entrenchment view of the Constitution, which was his central theme. Now, let me contrast, and let me just say, I hope we'll hear later, I'm sure the other panelists will talk about it. You might say, did he have too narrow a view of how to look at democracy? Was he looking at imbalances of public power and not taking into account enough imbalances of private power that actually have ultimate effects on the public sphere? Was he looking too much at incumbents rather than distortions through the incumbency rather than distortions through private wealth? Now contrast that with gerrymandering. So I think he would have thought campaign finance, that's kind of a success for the Elian theory, but gerrymandering, we're now meeting here in the shadow of that great decennial event known as the redistricting that gives us people in Congress with seats more secure than in the Kremlin, right? And redistricting handled by state legislatures, didn't Tennessee just trisect Nashville? and New York forced red Staten Island to be in the same district with Park Slope, Brooklyn, right? This is happening right now. Now, when legislatures do this, of course, they're considering a lot of things. They're trying to work in the shadow of what John thought the greatest high watermark of the Warren Court was, the 1964 decisions in Westbury versus Sanders and Reynolds versus Sims, the cases that brought about one person, one vote as an interpretation of the Equal Protection Clause. And he's actually dedicated the book for Earl Warren. You don't need many heroes if you choose carefully. And he was thinking, I think, of Westbury and Reynolds as sort of the perfect example of judicial review that enables democracy to function better by interpreting the Constitution to reinforce representation. Okay, but there are many ways to draw equipopulous districts. And of course, if you try to attain partisan advantage, or if you try to crack or pack or stack voters into districts for partisan advantage, what could be more of an example for John than the ins trying to make sure that they stay in and keep the outs out? So I think John would probably be horrified with our political map and with the kind of self-reinforcing cycle of incumbent protection that goes through partisan gerrymandering. And he would probably think the court has been remiss because first in 2004 in Veith versus Jubileer, the court almost gave up on ever interfering to stop partisan gerrymandering. And then in 2019, they really gave up. 5-4, the court said it's a non-justiciable political question. You cannot allow courts to decide whether partisan gerrymandering has got too far. It's not like one person, one vote. Just because you can decide that each person is entitled to have an equal say in the election outcome doesn't mean a person is entitled to his political party being represented in numbers proportionate to their popular representation within a state. It's non-justiciable political question, and decades of efforts to try to create the Reynolds versus Sims of partisan gerrymandering died with the Rucho versus Common Cause case in 2019. So John would say, I'm sorry, you've been very remiss, court, you didn't read my book, and I don't think you've done a very good job, and this is a real problem, and American democracy is impaired as a result of it. Or would he? Because in his very last work, including an article on gerrymanders in 1998 in the Stanford Law Review, he did say, I do wonder if there's an administrable test that has the ring of constitutional law to it. And of course, as Jenny described, he thought that one strength of his theory is he could root it in the clauses of the Constitution. But he also admitted that some of the clauses forced you to improvise a little bit. Obviously, something like cruel and unusual punishment, the term unusual means you have to think about what's unusual, and the term equal protection is equally indeterminate. So I think in the end he would have said that was a failure, Rucho was wrong, the courts should have entered the fray and decided about partisan gerrymandering. I do think he would see the attempt for current state legislatures to rig the process of congressional districting in their favor and in a way that distorts populist representation would be a failure. But then, Jenny, that's just on what he would say about the first part of the thesis, and just two examples. What would he say today about the second part of the thesis, judicial review to intervene to ensure that discrete and insular minorities don't suffer the political, the results of their inability to influence political processes the way majorities can?
Yeah, so I think he'd have a lot to say about it, though I'm not sure he would have clear answers on some of it, as I'll describe in a minute. So I think there are three issues that are currently very live in the Supreme Court that his theory speaks to. The first relates to race-based affirmative action, which the Supreme Court will be hearing cases about in the next term. The second, LGBTQ plus rights, and in particular, the evolution of the debates over that to the confrontation between claims of First Amendment rights of either religious liberty or free speech to respond to some of the laws and statutes that have been enacted to protect the rights of LGBTQ plus Americans. And the third cases that implicate his theory are the cases on abortion. Now, I'm going to kick the cases on abortion over to you, Kathleen, in the next part, because women are not a discrete and insular minority, and so the question of how he grapples with groups that are not discrete or insular, women are not discrete because they're all over the place and they're actually a majority in society, so they are hard to fit into the theory exactly. But I'm going to talk about the first two, the question of race-based affirmative action and then the question of LGBTQ plus rights. So on affirmative action, Ely talks about this in Democracy and Distrust, and it's a good example of where his theory points in a different direction than some other theories might in terms of how to interpret the Equal Protection Clause. And basically he looks at the issue of affirmative action and says, from the perspective of his theory, that is that we should be concerned about acts that harm discrete and insular minorities, we shouldn't be worried about affirmative action. And the argument he makes is that majorities enact this policy, and we should trust to the political process that they're not going to unduly harm themselves by enacting policies that benefit a discrete and insular minority. And that that's one of the things that should be left to the political process, because when a majority does that, we shouldn't be too concerned about it. The current debates about affirmative action in the Supreme Court in part involve arguments about discrimination against Asian Americans in affirmative action. Although he doesn't talk about that in the book, he actually does talk about discrimination against Jewish Americans as a sort of possible concern in respect to affirmative action debates. But again, he still comes to the conclusion that because of the nature of the political process and the fact that that it is that process of providing rights for groups that have traditionally been discriminated against, that results in the policies, that he concludes that it's not a place where the court should interfere with what is otherwise part of the political process. I think it's interesting, there's some recent Supreme Court decisions that actually relate the two strands together a bit. So one is the case from Michigan involving the statute in that state that said that affirmative action could only be done by constitutional amendment to the Michigan Constitution. And Justice Sotomayor's dissent in that case uses the kind of representation reinforcement theory to say that that changed to the political process in a way that disadvantaged discrete and insular minorities, because ordinary political processes could be used to set other priorities for university admissions in Michigan. You could go through the ordinary process to say we want to have athletes or legacies admitted at a higher basis or easier basis to the public universities. But you set this higher threshold of constitutional amendment to allow racial minority groups to have affirmative action, that was an example of changing the political process in a way that harmed discrete and insular minorities. So I think he would have had a lot to say about current and recent cases about affirmative action. On the issue of LGBTQ plus rights, he also talks about that. I mean, the book is written in 1980, so some of the language is a little jarring when you read it today in terms of the discussion there. But he definitely talks about LGBTQ plus Americans as people who fit into the definition of discrete and insular minority. It's a group of people, and he also talks about the ways in which prejudice and discrimination might lead people to not organize politically or not to be out in a way that facilitates that. What I think, and I think in that way the discussion presages, although he doesn't get into the kinds of details of later cases like the marriage equality cases, sort of it certainly speaks to that. Where I think the book doesn't give us a lot of answers are some of the current conflicts, or at least not obvious answers as to how he would have thought about it or how one might apply his theory, where you have claims of conflict of rights, and whether one accepts that framing is part of how one might approach the question. But cases like Masterpiece Cake Shop, where you've got a baker who says, I don't want to bake a cake for the wedding of a same-sex couple, and now in the 303 case, I don't want to make a website. And the claim is for a same-sex wedding, and the claim is that it requiring me to do so because of non-discrimination law infringes on free speech rights or First Amendment rights. And that's a contest of two rights posed against one another, First Amendment free speech rights being ones that are part of the channels of the political process, and equality norms against a discrete and insular minority. I think in these cases, there's certainly a flavor to the arguments that those claiming the desire to have a religious exemption from non-discrimination norms are also claiming to be minority groups that are discriminated against in society, though I think there's sort of contestation around those kinds of framings. But there, I think his answer doesn't exactly tell us where his theory would go in terms of what we do when we have the contest of different claims in the framework that he lays out. So I think that there's more to say there, and if he were alive, we could ask him how he would flesh out those answers. But since he's not, we can't ask him. But I will ask you, Kathleen, on the third thing I've raised, abortion and other issues related to women's equality. Women are a problem in his theory, or not a problem, but something to be grappled with because they're neither a discrete nor insular minority. So what would he have to say about that?
Yeah, well, thank you, Jenny. And I do think that gets us to some of the most controversial parts of the book at the time. John lost his cachet with a lot of liberal and progressive allies over his saying that Roe versus Wade had no foundation in the Constitution. Now, that was all about his interpretation of the Due Process Clause. Since Roe had been rooted in substantive due process, in fact, the famous pastel green redness remark was about the lack of any textual or structural authority for an interpretation of the Due Process Clause as a source of substantive rights, such as a right of privacy against state intrusion. So that part of his book was really about the Due Process Clause, but it was controversial at the time. I do want to just comment on the gay rights passage, which is very brief. I think it's hard to realize from a contemporary standpoint just how astonishing it was to have gay rights mentioned at all in a constitutional argument at the time. This is 1980. It's 6 years before Bowers versus Hardwick initially rejected the right of privacy that was later upheld against state criminal intrusion in Lawrence v. Texas. And the famous Hold It Lester passage, which is, a little bit what you're referring to in the archaic language, was astonishing. It was the first major constitutional, Professor Schachter can tell me later if I'm wrong, but I think it was the first major reference to the idea that there is an important egalitarian justification for striking down laws that discriminate against gay people. So, on the ground that this may not be a discrete and insular minority, because the gay people are everywhere, but it's not insular, not physically segregated, but because of the inability to protect yourself in politics because of the penalties the closet imposed on at the time, you would pay a social cost, as he described it. Gay people were not self-organizing in the way that other groups could be if they could be open about their group status. That was pretty radical. Women, not so much. The chapter that focuses on women, as Jenny says exactly, John used to say women are like the Holy Roman Empire. It was neither Holy Roman nor an empire. Women are neither discrete or insular nor a minority. In fact, his exact line, if I've got it here, as if it weren't enough that they're not discrete and insular, they're not even a minority. I'm trying to capture his cadences. Now, that passage of the book, pages 164 to 70, basically says it's kind of a rejection of what later Justice Ruth Bader Ginsburg did through the cases that brought a norm against gender discrimination into the 14th Amendment Equal Protection Clause. He's kind of saying you didn't really need the court to come in and strike down laws that prevented women from being bartenders or members of the bar or having the same Social Security or military retirement benefits as men in their ability to confer them on their families. It's an implicit criticism of a reading of an implied anti-sex discrimination norm into the Equal Protection Clause because, as he said, if you're not discrete, insular, nor a minority, or you don't have the other special exception like gay people that you can't self-organize because of social stigma, he basically said, and I quote this from page 169, if women don't protect themselves from sex discrimination in the future, it won't be because they can't, but because they don't choose to. And there's a little passage about false consciousness in which he says it's not really like women have internalized the norms of inferiority or have become walking archaic and overbroad stereotypes. He's just saying maybe they have other things that are more important than fighting sex discrimination. So it's an interesting, controversial section of the book, and it's poignant because I think what John really thought at the time, this is 1980. So the Equal Rights Amendment has been promulgated by Congress, it's been sent to the states, and Congress has just in 1979 extended the deadline for ratification to 1982. And I'm pretty confident John thought the ERA was going to be enacted into the Constitution, and then we wouldn't have to have an argument about an implied sex discrimination interpretation of the Equal Protection Clause. We were going to have a clause, and then we could deal with the clause. And he writes in a footnote that's kind of funny. He says, I'm just thinking women might be too busy to support their own rights because in polls it seems like men support the pending ERA more than women do. Now, of course, 1982 comes and goes. We don't have 38 states. We have 38 states now because Illinois, Nevada, and Virginia ratified, and there's current litigation and political debate about whether that counts as a ratification, whether the archivist must or can't certify it as the 28th Amendment to the Constitution. But I think, John, what I most would want to talk to him about is whether he needed to deepen his understanding of the footnote 4 concepts to extend to forms of political disability that come even to those who are not discrete and insular minorities, or not discrete and ubiquitous minorities, whatever you want to do to reframe it. I think that he would have been surprised to learn about all the scholarship that's happened in the last 40 years about other structural sources of inequality for women and for other people in a society who've have enjoyed certain political opportunities, but don't seem to have capitalized on them in a complete way as they might. So I think that for John, there's questions I would want to ask him about the majoritarian side is, do you think you're accounting properly for the structures of power in democracy? Are you underestimating inequalities of private power? And do you think you're accounting entirely for the structures of inequality in our society? Or do you think you got a little too hooked on discrete and insular minorities when there are other bases for systemic long-term inequalities between groups of people? And I'd really like to talk to him about women on that question. But Jenny, just to close it out, because we have to clear the stage for Larry and Jane, take us to the world. You know a lot about comparative constitutional law. Where would John fit in his theory relative to other constitutional traditions? I mean, there's been a lot of constitutional activity since Democracy and Distrust. The Berlin Wall came down. We had a lot of new constitutions in Eastern Europe and South Africa. And, of course, the Canadian Constitution. Would John be a Canadian today?
It's a great question. I think one of the interesting things, and I do study comparative constitutional law, and there was recently a law review symposium on democracy and distrust in comparative perspective. And one of the things that's interesting about comparative constitutional law is some aspects of American constitutional law really get picked up in other constitutional democracies. I mean, you go around the world, one of the things that's a little bit embarrassing as an American is you go to most other places and lawyers are familiar with the big cases in the US Supreme Court. Like they know the big landmarks like Brown versus Board of Education, but they also even know the current cases that our Supreme Court has decided. So there's a lot of attention to American constitutional law in other places, even when the US is engaged in debate about whether or not we should pay attention to what other constitutional courts do. But one of the interesting things is some American constitutional theories travel well and some don't. So originalism is one example of an American constitutional theory that really hasn't gotten much traction outside the United States. A little tiny bit in Australia, but in other places, originalism is just not something that constitutional courts or theorists have picked up on. Ely is a little bit more of a mixed bag. When you look around the world, there are some places like Canada is one of them where scholars have picked up on Ely's theory, and indeed it seems to be some other common law countries like Australia, Canada, where you see constitutional scholars picking up on his theory, discussing it. On the other hand, basically no sort of pickup of Ely's work in places like Germany or South Africa. Germany, perhaps civil law countries, you see sort of no sort of interest in it. And in places like South Africa, which is a sort of common law system, there seems to be, because the constitutional order is itself imbued when it was enacted much more recently with a kind of values-based constitutionalism of the kind that Ely rejects in trying to come up with a interpretive versus non-interpretive theory that focuses on the sort of structural arguments, that there isn't the same angst about the nature of judicial review, and there is a more sort of overt focus on a kind of teleological interpretation of the Constitution based on a value like human dignity in the German constitutional system or in the South African system. So I think it's interesting to see which American constitutional ideas travel to which parts of the world and what that says about our system and the systems where our theories are picked up or discarded as not particularly attractive.
Well, Judy, we have to close, but the one thing I know is we'd love to have this conversation with John, and we're so glad we can have it virtually through the conversation that's about to follow. Yeah. So thank you so much for chatting with John, with me about John.
Yeah, he's here as in spirit. Yeah. All right, and now we get to do we turn it over?
Turn it back to Michael.
Or,
thank you, everyone.
yeah.